So thanks for joining us, this webinar organised by Redfern Legal Centre. So we're going to have three speakers. The first is Sam Lee, who will give an overview of current social distancing laws and also a review of payment and review options regarding fines. Then we'll hear from Peter O'Brien, who will talk about challenging COVID fines via the court process and what action people can take if police have acted beyond their power or unlawfully. And then we'll go to Emmanuel Kerkyasharian, who's a barrister, and he will talk about his legal concerns with the public health orders and also what kind of legal challenges he envisages we might see through the courts. So thank you so much to you three for being here. I can give more of a bio as we go. So Sam Lee is solicitor with Redfern's Legal Centre's Police Accountability Practice. Sam, previous to working at Redfern Legal Centre, has also worked at Legal Aid New South Wales in the inner city local court and indictable appeals sections, and also in the in-house counsel unit. And she's also worked in the criminal law review unit at New South Wales Attorney General's. So I'll hand over to Sam to talk about her topic for around 10 minutes. Thank you, Sam.
Thanks, Alexa, and welcome everyone. Thanks for joining us here at Redfern Legal Centre. So I'm going to just give you a basic rundown of the current social distancing laws and highlight, I guess, or flag the major changes in the laws just recently. The laws were updated on Monday, so they have changed, and they've changed quite a bit throughout this whole COVID-19 pandemic. I know a lot of people have been left very confused. I hope I can answer some of your questions tonight or provide some light about where they're up to, but I'm sure there will be questions because the laws themselves are quite difficult to understand. So first, I'll just point out that you no longer need a reasonable excuse to leave your home. So you can leave your home for any particular reason. You can only have 5 visitors at your house. That though doesn't include your house members. And it doesn't include a number of people, for example, someone that may be attending to give medical or healthcare to someone in the house, someone fulfilling childcare obligations, fulfilling obligations around shared parenting. But it does, so children are included as visitors. Who is considered to be a parent is quite broad within the order and does include those with shared parenting arrangements, de facto relationships. It's quite a broad definition of parenting. You can also stay overnight at someone's house. However, you still need to comply with the 5 person's visitor limit if you are travelling as for example, a group or a family to someone's house. You have to comply with that 5 visitor limit. You can now travel within New South Wales, which was something that was restricted until Monday. So you can get in your car and go visit a relative or a friend in other parts of New South Wales. There's no particular restriction on distance or who is in the car. The only thing you need to be aware of is that some states still have some border controls, so you need to update yourself on what those border restrictions may be. You can also visit people in aged care facilities, but it's quite limited. It's for the purpose of care and support, and there can only be a maximum of 2 persons, and they can only visit for up to a 2-hour maximum. So obviously aged care facilities are quite vulnerable to the COVID-19 outbreaks, and that's why there's still restrictions on those particular facilities. There's still restrictions on gathering as a group in a public place. I emphasise it is about public places, that you can only gather in a group of up to 10 persons and no more than 10 persons. And again, that also includes children counted in those 10 persons. So example of public places are parks, beaches, also including the water in the part of the beach, footpaths. It's quite broad with what public areas may be, some shopping centres, but schools are not included as public areas. There are places where this 10-person rule doesn't apply, and that is for the purposes of work. If you're getting public transport or you're in a car. There's also some new limits on weddings and funerals and religious services, which I'll go into. And there's other areas where the 10-person gathering doesn't apply. For example, if you're moving house or inspecting property for sale, and also if you're providing care to vulnerable people, such as a charity. There's places where it doesn't apply, for example, airports, hospitals, aged care facilities and schools and universities, and some other places such as Parliament and correctional centres. It's important to point out that there is no fine for actually not standing 1.5 metres away from a person. We've heard that a lot being said by the Prime Minister and Premiers, but it's not a specific offence. It's just a directive. So there's a lot of confusion because there has been many directives, but not all of them have made it into an actual order or form part of a law. There's new limits in terms of weddings and funerals, as I've mentioned. You can now have no more than 20 people, which is up from 10 at a wedding. But that doesn't include the people getting married, a photographer or the person conducting the service. For funerals, you can have up to 50 people, and for religious services, it can also be up to 50 people attending those services. Another new aspect to the laws is that restaurants can now, you can go out to dine at a restaurant, and restaurants, cafes, pubs that have restaurants can have up to 50 patrons, but they need to maintain that 4 square metre rule between customers. So if you're sitting at one table, the table next to you has to be at least 4 square metres apart. Some interesting new rules is that when you do attend many venues, including a restaurant or bar, is that you are required to provide your name and contact details to the venue. The purpose of that appears to be is that if there is an outbreak of the virus at the restaurant, then the public health would be able to contact you, and venues are required to keep those details for a certain period of time. And are required to pass on your details to public health officials when required. You're still required to self-isolate if you are diagnosed with a COVID-19. And if you're coming in from overseas, both through the airport and via vessel, then you are required to quarantine for that 14-day period. So that hasn't changed at all. Outdoor swimming pools and indoor swimming pools are now open. There are different restrictions for indoor and outdoor swimming pools. Some tougher restrictions around indoor swimming pools. It's mainly just opened for squad training rather than just general members of the public. The other big changes are to just businesses in general. A lot of businesses now are allowed to open, but must meet that 4 square metre rule between patrons. And most businesses need to have what's called a COVID safety plan. And that's quite a detailed plan in regards to hygiene, and you meant to, as a business, have a checklist to ensure that you're meeting that COVID safety plan. The fines and penalties still exist. So if you do breach any of the orders, then you can still be fined by police for breaching those orders, and that fine continues to be $1,000. Obviously, police are not required to or mandated to fine someone. They can still just give someone a warning, or try and negotiate the situation and ask someone to move on, I guess, if required in certain circumstances, but they are not mandated to provide someone with a fine. I think I've kind of provided the main overview of the actual powers and the new changes to the laws. So I might wait for further questions before going any further. I might just flag now that there are options that if you do receive or have received a fine, then you do have options, and those options could be a part payment of the fine. They could be what's called a work development order. They could be about setting up a payment system, or they could be about challenging the fine in a court, which is what Peter will talk about shortly. So I think it's really important to emphasise that if you do have a fine, it's a very hefty fine, and the worst thing you can do is just put your head in the sand, because the thing with fines is that they get worse over time. If you don't pay the fine within a certain time frame, then the fine will increase, and eventually enforcement orders come into play. So I advise people out there that do have a fine to contact Redfern Legal Centre to get some advice and see what your options are in relation to your matter.
Thanks, Sam. Someone's asked, are we free to protest?
Yes, this is an interesting question. I've had a few people ask it. Look, there's nothing within the orders, and I'm be happy for Emmanuel and Peter to jump in on this one. There's nothing in the orders to say that you cannot protest. The only thing that restricts you is the 10-person gathering rule, and that's where the difficulty comes into play, is that people cannot gather in public spaces in large groups beyond 10 people. So I'll be interested to hear what Peter and Emmanuel have to say about that. But there's nothing that seems to suggest that if you have a group of 100 divided into groups of 10, that you may still be complying with the law if they are within groups of 10. Maybe Peter and Emmanuel would like to have a go at that one.
Thank you. That sounds like a meaty one for later on. I'll ask one more question before we move on from the chat, and that is, you said that there was no fine for, not keeping 1.5 metre distance. So what are the fines for? Are they for not staying below the group sizings?
Yeah, so within the orders, there is no particular requirement to be at 1.5 distance for individuals, that is. So the fines are for breaching what I've just explained in the orders, which is about not adhering to the 5 visitor within your home rule, to not adhering to the 10-person gathering rule, for businesses that don't apply to the 4 square metre rule, the fines, and for weddings and funerals to go over the limit of persons rule. So the fines are all for all those types of offences.
And are the fines larger for businesses?
They are larger for businesses. Just let me check what that fine is so I can provide it to you. So it's an on-the-spot fine of $1,000 for individuals, but for businesses, it's $5,000 for corporations. Yeah.
Right. Okay, thank you, Sam. We might move on and hear from Peter O'Brien in relation to challenging court fines via the court process, and also what legal action people can take if police have acted beyond their powers. Peter is the principal lawyer and founder of O'Brien Criminal and Civil Solicitors. Peter is a highly experienced criminal defence and civil lawyer with more than 20 years of experience in New South Wales and interstate. And some of his key experiences prior to working at O'Brien's includes working at Legal Aid, Aboriginal Legal Services, and we send quite a few of our clients over to O'Brien. So over to you, Peter.
Thank you very much for having me in this podcast, or what do we call it?
We're calling it a webinar. Zoom meeting.
Zoom meeting. It's a pleasure to be here, and I'm glad to be presenting. So I've been asked to talk about challenging COVID fines via the court process, and also what avenues or legal action might be taken if police have acted beyond their powers. I'll just start off by, in terms of that first area, so challenge a COVID fine via the court process, and encourage people to look at the Redfern Legal Centre fact sheets in relation to that, because that is a very helpful fact sheet that sets out these sort of issues in a really straightforward manner, and is easily digestible, and so I recommend and commend Redfern Legal Service for putting that together, and encourage people to have a look at it, intending on challenging their COVID fine in court. Now, obviously, you can challenge a COVID fine in court if, for example, you don't believe that you've broken the law. You might believe that you've got a reasonable excuse, as it's set out in the Act, and I'll come to that in a moment. If you think that the penalty was too harsh, the ordinary fine of $1,000 was too harsh for you and you can't afford to pay it, might be a reason why you challenge it. Alternatively, if you want the court to consider, or if you want consideration given to matters that are relevant to your circumstances, for example, mental illness or homelessness, any other sort of disability that you might be labouring under, and that might suggest that the fine was too harsh, and there might be another way of dealing with it. Redfern Legal Centre recommends challenging the fine by internal review by Revenue New South Wales first, and obviously if you can do that, you ought to do it. But if you decide to go to court, there are two mechanisms by which that can happen. So there's two ways you can appeal the matter to court. Firstly, on the back of the penalty notice, there is a form that you can fill in and then post using the snail mail to Revenue New South Wales. Or alternatively, you can appeal to court online, and the website of www.revenuenewsouthwales.gov.au fines go to court is the website, and again that is produced and reproduced on the Redfern Legal Centre fact sheet, which is available online through the Redfern Legal Centre website. If you go to court, there's a standard process that will occur. You'll be provided with a précis or a summary of what you're alleged to have done, and how you're alleged to have breached the provisions in the Public Health Act, which is most commonly the offence which is applied. Section 10 of the Public Health Act is the most common offence that's given rise to these penalty notices. And so that the police are required to provide you as the defendant with a copy of the a fact sheet, which is meant to specify what you're said to have done. And obviously you must look at that very carefully, because if you're intending to plead guilty and try to extract some sort of leniency from the court, then what is written on that sheet will be accepted by the court as exactly what did happen. Similarly, if it's not correct and you're pleading not guilty, then you'll have some idea of how the police are particularising their charge against you in relation to the offence of breaching the provisions of the Public Health Act. It is likely, particularly at the moment, that you won't get a court date for some months away. I've read that matters are not being set down until the 1st of October. And indeed, the only matters that I've represented people, or people have sought my advice in relation to these matters, have been where the police have actually issued court attendance notices themselves and put it straight before the court. And so they've been dealt with before the 1st of October, but it would appear to be the case that if you do challenge the fine through the court, you won't get a court date, even for a mention, in other words, the first hearing of the case, until October this year. Obviously, there are risks. There are risks of going to court, because once you go to court, the entire spectrum of sentencing options are available to the court, whereas the police are providing fines in the order of $1,000. The section itself, Section 10 of the Public Health Act, allows a penalty of up to $11,000 and or 6 months imprisonment. So the whole range of options are available to the court, and that has to be matter to court. So it's very important to get some advice about doing it. Similarly, if you're found guilty, you may well be convicted of the offence. So even a fine imposed by the court will carry a conviction, and in some cases that can present some difficulties for you down the track in relation to your employment or even international travel in some instances. So that also needs to be considered. I wanted to just talk about this concept of reasonable excuse for a moment, because the Section 10 of the Health Act is a very brief section indeed. All it says is that once a direction's been given by the Minister for Health, in this instance, and it's breached, a person must not, without reasonable excuse, fail to comply with the direction. So this concept of reasonable excuse becomes very significant. And there have been, and there's no real definition of what a reasonable excuse is. An excuse is, of course, a reason that you'd give in order to explain why you've done something or you haven't done something. And reasonableness is just a gauge of what's fair and sensible. So if it's fair and sensible and you've got you're giving a reason, then it's potentially a reasonable excuse. So the question that was posed a moment ago, are we entitled to protest? The question is whether that would be a reasonable excuse. So at the moment, the direction is you can't be in gatherings of more than 10 people or in a household of more than 5 visitors. So if someone were to say that they were engaging in a protest, exercising their rights of assembly, and engaging in a legitimate political form of expression, the question is then for the court to determine whether that would be a reasonable excuse. And one might think that the court would consider a couple of things. First of all, it would be incumbent on the court to consider the person's right to freedom of expression and assembly. Or on the other hand, the the import of this legislation and these directions are to prevent large assemblies of people, so to prevent the contamination of groups and clusters of people. So those matters would be considered together to determine and of course there hasn't been a determination as to whether that's a reasonable excuse.
Peter, can I ask a question from the chat? And that's setting aside the issue of reasonable excuse and balancing those exciting rights. Someone's asked the question about the legislation says outdoor venues are limited to 500 people, but then there's also this rule you can't gather in groups of more than 10. Can you explain how those two things are not contradictory, or explain? Well,
they are inevitably contradictory, and I mean right throughout this pandemic, there's been a real lack of clarity in relation to what is and what isn't reasonable for a person to do, and there'll be many minds that will beg to differ in relation to that. And what that I expect will be one of the things that a court would have to turn their mind to if someone were to be issued today with a penalty notice for failing to comply with the direction. For example, if they're in a protest situation, that there is this dichotomy between what's allowed at a public venue as opposed to what's allowed in a park or a street or thoroughfare. So that would be very relevant, because the actual policy behind the direction would be relevant to what is reasonable and what is not. And so that would be a very relevant matter. What the Act also enables the police to do, which I've seen a client of mine refuse to do, was provide the police are entitled, if they suspect that a person's contravened a direction, they're entitled to demand that the person state their name and address. Now, evidently, that would be for the purpose of understanding who they are, so that they might issue a fine, but also where they are living, so that when most of these fines were issued when to determine how far away they were from home. Now, what isn't required of a person to do, even now, is give any more information than that. That anything they said could be used against them, then potentially that would be inadmissible. So that the conversation that's had by police with police by the defendant would be arguably something that could be challenged as to the admissibility in court, going to what was said to police and whether or not what was said to police was an excuse which was reasonable or otherwise. At the outset of the beginning of the directions and restrictions, you may well have seen the listing of 16 excuses that were said to have been reasonable. I won't repeat them, but they were things that were, for example, obtaining food or goods or services for the needs of the household, travelling for the purposes of work, attending for the purposes of attending childcare, exercising, attending weddings or funerals, and those type of matters, undertaking legal obligations. That list that you may have seen was not exhaustive and was certainly not prescriptive as to what the only things that constitute a reasonable excuse, but that was published by the New South Wales Department of Health in an endeavour to assist people in understanding what a reasonable excuse was or is. And of course, it's relevant to have a look at that to determine whether or not, look at those particular, the set out of those particular items and reasons to see if your excuse might fit into that categorisation. I want to turn just briefly, if I can, to the issue of fines, because it might be that you've got this $1,000 fine and you simply can't afford to pay that sort of money, that it represents too much of an impost against you. Now, the magistrate in a local court is required mandatorily to consider whether or not the fine was excessive in your circumstances. The Fines Act requires, before the imposition of a fine, that in exercising their determination to fine you, a court must consider your means and whether you're reasonably and practicably able to pay the fine. So if you can demonstrate, and I think anyone, for example, on a new start allowance, even with the higher rate over this course of this period, or that you have a very meagre disposable income and are working on a lower income, that you could demonstrate quite easily that either the fine should not be imposed against you at all, or alternatively that the fine should be reduced to something that is that you are capable of paying and that you have the means to pay.
Peter, I'm going to give you a 2-minute warning.
Okay, thank you. So the court is required to consider your means and make sure that you can afford your fine, afford to pay the fine. Turning brief, I should just say, in relation to children under 18-year-olds, they can obviously also go to court and challenge fines and the imposition of the, and indeed challenge the alleged offence. The children will end up in the children's court, and the maximum fine that is available in the children's court will not be the $11,000 fine, but rather a maximum of $1,000 for children. So that will be the maximum fine that a children's court can impose against a child. And generally speaking, children are not required to pay those sort of fines in that sort of magnitude. Just quickly then, turning to whether or not legal action can be taken, the power of arrest hasn't changed. Arrest should not be exercised unless it's necessary, and whether a police officer suspects on reasonable grounds that the offence has been committed, and in addition to that, that the arrest is necessary for the purposes of stopping a person repeating the offence, or stopping the person from fleeing from police, or to protect other people. Now, most of those circumstances would not apply. So if you have been arrested for this type of offence, then it is very possible that that arrest was unlawful, and you may well have an action against arrest. Similarly, if there's been an application of force, if you've been effectively detained, the direction pursuant to Section 10 of the Health.
Peter, someone's asked a question. Can you hear me?
Yes, you're cutting in and out, but I think I've got you. Yeah.
Someone's asked a question, which is that in their experience, often the police officers will get people to admit that they have committed an offence and otherwise threaten them with arresting them if they won't admit to the offence. Is that something you've come across?
Yes, of course, and that sort of conduct is not only improper, it's potentially unlawful. If a police officer has threatened to arrest you, that is an assault, unless it's justified. And it's certainly not justified to threaten to arrest someone if they don't tell you, if you don't tell them, I should say, the police officer, why you're out and about or why you're doing what you're doing. The reality is you don't have to do that. You have an obligation, you have an entitlement to say nothing except state your name and address under the Act. And you don't have to tell them why you're out and about, and you certainly don't have to incriminate yourself. So if a police officer says to you, look, if you don't tell us why you're here, we'll arrest you and find out, well, that would, in my view, constitute an unlawful arrest, and you potentially have a cause of action against the state.
Someone else has asked, if a police officer comes to your front door, say your neighbours complain, they think you've got too many people at your home, does the police officer have to have a search warrant to enter your home to investigate whether you've breached one of these offences?
Under the Act, let me just turn to the Act. It's section 112 of the Act provides the police officer with power to demand a person's name or address, or indeed someone who is apparently in charge of premises where a contravention is. What the legislation provides. Of course, police have a power under general police power legislation's LEPRA to enter premises where they suspect that an offence may be committed. So ordinarily, police would not need a warrant to enter a premises in those circumstances. But if that was not based on reasonable grounds that an offence was actually happening at that time, they may well be committing a trespass.
Okay, thank you. I might force us to move on and introduce Emmanuel Kerkyasharian, who is a barrister at Forbes Chambers, specialising in criminal law. He's got a background in law reform, having worked at the Criminal Law Review Division, and he's also worked as a solicitor for the Western Aboriginal Legal Service before coming to the bar. And most interestingly, he's one of the Wigs on the Wigs podcast. So welcome, Emmanuel.
Thank you so much, Alexis, and good evening, everybody. One of my concerns and my lead was about the public health orders themselves, and to talk about what legal challenges I envisage in relation to those orders it's the fact of the orders themselves that I think concern me the most, by which I mean we woke up a few months ago to learn that we ostensibly authorised a single person, the Honourable Brad Hazzard, to our entire way of life. To stop us from meeting for cultural reasons, meeting our friends, to undermine. And we'd authorised him to do it in circumstances where he's not faced a single question on the floor of our Parliament about what he's done. Now, I don't know if when Parliament authorised these things, they imagined that Parliament wouldn't be sitting. But that is, to my mind, the biggest change in our law that I've experienced in my lifetime. And it's quite frightening to me. We've, in effect, legislated powers that for a short period of time now have given dictatorial control of the state executive. If I use a word like dictatorial control, you've got to take into account, obviously, that these powers have now been used ostensibly for our benefit, arguably to our benefit, reasonably arguably to our benefit, and we've been fortunate, perhaps, in that sense. But power corrupts, and it seems to me, at least, that that kind of power will not be put in the hands of a single person, and we're taking steps to claw that back into the future. It's something we need to think about. I don't think it should be a fringe right-wing issue, which it's so often portrayed as. I hope that progressive voices take up the arguments against allowing this kind of thing in the future. That's not to say we don't need emergency powers. It's not to say we don't need ways to deal with these sorts of things, but to allow someone to change our lives so significantly without recourse to our representatives and their questioning is a grave concern. The second concern I have about the orders is it's really the distinction between what the orders say on paper and what our politicians and perhaps frightening say. Sam mentioned earlier the confusion about the 1 metre directive. I'll give you another example in a moment, and what we're told it is. And what we're told the police who force, and that divide really big concern. And so this is what is as they are now, and they have been. But one of the interesting provides that you might provide one could leave one's house without a reasonable excuse. I can't find any prohibition or any requirement that a person who has left their house for a reasonable excuse, with a reasonable excuse, would have to return home. So, for example, if you left to buy a kebab because you were hungry and you needed food, you've left with a reasonable excuse. And I hasten to add that this shouldn't be taken as legal advice at this stage, but it seems to me that you've left with a reasonable excuse. The fact that you find yourself in a park afterwards is, to my mind, not an offence at all. And so I don't know where the magistracy will land when it comes to consider issues like this. But the fact that there was a difference, and there continues to be differences, between what we are told by our political leaders and what the law actually says is a real problem. Turning then to the legal challenges, that's the first legal challenge I see in relation to some of these notices and fines that have been issued. The second is something that Peter's already touched on, which is the right to silence. So when these things come to be argued before courts, if they come to be argued, as I expect they will, did the police caution them before talking to them? Did police officers walk up and say, hey, what are you doing out here, without cautioning them that they had a suspicion or they needn't speak to them, and if they did, it would be used against them? The third challenge, and I'm going to run through these fairly quickly because they can be quite technical as well, concerns the question of on whom the onus of proving a reasonable excuse or proving a lack of reasonable excuse falls on. So under the Summary Offences Act, which provides effectively the same sort of defence for various offences, the Summary Offences Act says that the reasonable excuse, the proof of that reasonable excuse, falls on the defendant. The Public Health Act does not say that. So on one view, it's the case that the police have to prove that you did not have a reasonable excuse for leaving. Now, the law on this is very unclear and really won't be decided until it is decided. The relevant High Court authorities basically say you look at the legislation itself. My own view is that the magistrates will put the onus on the defendant, and I suspect the appeal courts will as well, but it's certainly something that needs to be considered and no doubt run. I imagine, in the first cases that come to be heard about this, I hope that that's run. The fourth issue is whether the minister can unilaterally decide that an excuse is not reasonable. So the orders that had set out reasonable excuses in a list tried to accept things as being not reasonable. And the problem is that the problem is from the orders perspective, is that the reasonable excuse defence is actually included in the Act and not in the order. So if you can convince a magistrate that your excuse was reasonable, it's at least arguable that the minister's view about what was reasonable or not is irrelevant. So I think that's going to be a point of contention and something that may well be argued about. Fifth, and this is a real kind of nasty technical matter, in order to prove the offence, the police have to prove, or the prosecution have to prove, that you had notice, that is, the defendant had notice of the condition. And that's not something that should, if the law is being applied properly, be assumed. So I don't know how they're going to do that. I really don't know. I imagine they will be asking the magistrates to assume that people knew. But an order is not a statute. It's not statute nor delegated legislation. There's no presumption that you knew about it that I can find, unless I've missed something in the Act. So I don't know how they're going to prove that. And that's something that's going to be very interesting to look at. The sixth thing that I think will be challenged or will become interesting in relation to these orders generally are the constitutional challenges, in particular what's called the implied right to political communication, which is our sort of half-baked free speech right that has been implied out of our constitution by the High Court. You can make inroads into political speech. Political speech being what you imagine it is, so arguments about politics and so on. You can make inroads into it. When I say you can, the state can, the parliament can. And in effect, there's a question of proportionality. So is the inroad into speech, and here we would include protesting, necessary or proportionally necessary compared to the impact that it's having? Now that raises a whole host of interesting questions, one of which I think was astutely questioned about it by one of the questioners, which is, if the legislation says 500 people can go to an outdoor meeting, how is it proportional in those circumstances to prevent a political protest or require that to be minimised, to go down to only 10 people? I would also argue, in the context of this, that the risk that is presented through us in the narrative of COVID, which I've no doubt is real, but there's a difference between the risk that's presented to us and the risk and the manifestation of risk that can be proved to a court. And so when you come in to consider questions of proportionality, how they prove the effects and the risk will very much be at issue. So there's a case that Clive Palmer, of all people, is running in the High Court at the moment concerning the restrictions that Western Australia and Queensland have put in on travel to those states. And that there, the proportionality question will come into play, not as a political, under the heading of political communication, but under other headings of the Constitution. But we'll get some guidance, I think, from the High Court about that fairly soon. And that will feed into the question of protests and so on. In terms of the question that's asked, are we free to protest? Well, you're free to protest if there's 10 people. If there's more than 10 people, I don't know the answer. And I don't know the answer because I don't know the way that the courts will rule upon that. I strongly suspect that the police would take enforcement action if, say, 1,000 people turned up outside Parliament, although I don't know that for sure. Interestingly, one option that may be considered is approaching the Supreme Court for a declaration about that. So if you were an organiser for a protest, you might consider and take advice on seeking a declaration from the Supreme Court about your protest, saying to figure out beforehand whether or not what you're doing is legal. You might put into place a COVID safety plan and put that before a Supreme Court judge and say, look, take all of this into account. You know, is what I'm doing legal? Now, I don't know whether or not you can do that. That's something that needs advice, but it's certainly something that should be considered. So they're the bulk of the legal challenges. The other one I wonder about is whether, in fact, the orders that have been made are within the scope that's contemplated by the Public Health Act. I suspect they probably are, but that's something else that ought to be considered. So that's really, I think, all I wanted to cover. So,
thank you so much. As a public interest lawyer, very exciting to hear multiple angles for challenge. And particularly interesting, I think, in terms of proportionality, to think about the low numbers of cases of COVID in New South Wales at the moment, and how perhaps a protest today might be more proportionate than, say, one at a different time when we thought the numbers, you know, might blow up into a much greater number. So we've got 5 more minutes if people want to quickly put some more questions on the chat. I hope I haven't missed any because I cut out and my chat cleared, but I think we've put most of them. I do have one from earlier, which is, and whoever on the panel wants to jump in if you know, but someone's noted that that there was that news story about a man eating a kebab on a bench alone in the park who was fined, and Mick Fuller, the Commissioner for Police, announced that he would personally review all fines and charges made under these new laws. So somebody's asked, has there been any data released on how many fines there have been, and, you know, how many he's reviewed and how many have been perhaps revoked or altered as a result?
We have put in, Redfern Legal Centre has put in a access to information application, actually asking those particular questions. That's the answer due, I think, next week. So hopefully we'll have the numbers for you.
Great. I've got another question on the chat, which is, if an employer isn't ensuring staff respect the need for worker space in terms of meetings, what recourse does an essential worker have? I guess that's an overlap with employment law, perhaps.
Yes, I'm not an employment lawyer. It goes into a whole other area of law around employee safety. I don't know whether Peter or Emmanuel.
Yeah, I think a really good question. I mean, I know that our employment lawyers are providing a lot of advice on these kinds of questions, and employers certainly have duties to keep employees safe. The courts haven't looked very much at the particular situation of COVID, but we know that the risks are around close proximity and things like that. So it's all about applying the employer's duty to keep workers safe to this particular context. I think that's perhaps all I'd feel comfortable saying at the moment, but certainly if that's an issue facing you, our employment lawyers could drill down into that further. I encourage you to make contact with us. Someone else has asked, can anyone hazard a guess how quickly can one get a declaration or direction from the Supreme Court to see if one can protest? I just love the question too much not to ask it. Emmanuel, do you have an answer for how quickly you can get a declaration from the Supreme Court?
I mean, it should be fairly quickly is the answer to that.
Yeah.
The Supreme Court's sitting, the Supreme Court's effectively sitting, either it's now started face-to-face appearances, but it's sitting by way of AVL, if not face-to-face. So it should be able to be dealt with fairly quickly, and I imagine you could get some measure of expedition. But the important thing to do would be not to go off half-baked, so to make sure you've got all your evidence in order first and got some advice from probably an admin lawyer to sort of take that up.
Yeah, I mean, if anyone knows people who are organising genuine protests and want to explore that question, happy to put them in touch with the right people and get involved in that. So do let us know.
The other way that you might consider doing that is by seeking an authorisation under the Summary Offences Act, by providing the prescribed form to the police commissioner and then having them refuse to authorise the assembly, and then that will trigger a Supreme Court hearing on that refusal.
Indeed.
So that's all done through sections 23, 24 and 25, 26 of the Summary Offences Act. I think it's a form, part 4 of the Summary Offences Act that will enable that to be dealt with by the Supreme Court. So in those forms, you need to set out where it's going to be, how many people you anticipate attending at the assembly and so forth, and that will then authorise the assembly. And if the police commissioner objects, they need to have the court determine whether the assembly should be authorised. So that's another method by which the court might come to determine whether or not these assemblies are appropriate or lawful.
Great. Well, on that very exciting note, I'm going to keep us all to strict time, and thank you all very much for joining us. Special thanks to Sam, Peter and Emmanuel for taking some time out of your busy days to share your knowledge with us. As people would be aware, these laws are always changing, ever changing, changing quickly. So please do keep an eye on our website for our fact sheets, which we update as the laws change. We've recently launched a statewide, we've always had a statewide legal service giving advice to people about police powers and assisting people to make police complaints, but we've just expanded our fines practice to be statewide in relation to COVID-related fines, and we're also statewide in relation to people who have questions about the COVID-19 laws. So please spread the word and have your confusions answered, hopefully, by our lawyers. Thank you very much for joining and interacting and putting up your questions, and hopefully we'll see you soon at another one of these events. Thank you very much.
Thank you.